the table of content for today's presentations. First, I will start with a brief introduction about intellectual property rights in general, so you know what are we going to discuss. Then I will introduce what digital economy is, and finally we will go to all the main topics, which is copyright, artificial intelligence, e-commerce, how to make surveillance and how to enforce intellectual property rights, etc. But let's begin with intellectual property rights in general. What are we talking about when we talk about IP? We talk about different types of monopolies. Basically, an intellectual property right, it's a monopoly over a technology, a piece of art, a symbol that allows a company to avoid third parties to use that technology or trademark. So we have a different set of different intellectual property rights. We have the innovation patents and utility models. We have design patents, trademarks, copyright, trade secrets, domain names. Each one of them has a very unique object of protection. For example, in the case of innovation patents and utility models, what they do is to protect the technology or the process that a certain innovative object has. For example, it could be a mobile phone, or it could be the process about how to produce a mobile phone. In the case of design patents, what they are protecting is the aesthetic aspect of a product. It's only how it looks, how it is presented to the consumers, but not any aspect related with the functionality. In the case of trademarks, what it is protected is any symbol, any sign that your company can use to differentiate the products from your products from the ones of your competitors. So here we have the name of a company, the name of a product, but it also could be a logo, it could be a shape, a smell, music, any sign that can be used as to distinguish a product can be registered as a trademark. In the case of copyright, what it is protected is an expression of an idea, not the idea itself, but how it was expressed by the artist. But not only, when we talk about copyright, we're not only talking about art protection. For companies, and this is a topic that we will discuss in this presentation, copyright is also the method of protection for databases and software, which are very relevant in the digital economy. Then we have trade secrets. What trade secrets protect is any information that you know that has a value and you keep it away from your competitors. This means that, for example, your list of clients, all this knowledge that you use in a procedure to manufacture, or that has any business knowledge that you may have over a certain specific market, this should be protected as a trade secret. But also, for example, unregistered intellectual property rights, but that you will want to register in the future, but you still haven't done, then these are also trade secrets. So when we talk about trade secrets, we're actually talking about all the previous intellectual property rights that I mentioned as well. Finally, domain names is it's not an intellectual property right itself, but in the case of digital economy, they are very relevant because it's basically the digital address of your company. And they have the characteristic that once you have created your domain name and registered it with the proper authorization, it's really difficult to take it down. There are methods of dispute resolution. However, they're very strict. So companies should be very careful and should try to get them as soon as possible if they want to have a very specific domain name. But when we talk about intellectual property rights, we also have to understand what the main principles are. And there are two that are critical for learning how to develop a new protection strategy. The first one is the registration principle. This means that the company will not have any kind of protection except if that intellectual property right is already registered in a country. This is connected with another principle called first to file. That means that the company that files the intellectual property right first will have a priority over any other latest registration. So even though that in Europe this principle is not so strict, because there are cases in which unregistered intellectual property rights have certain level of protection, for example, well-known trademarks, or in the case of designs, even if they are not registered, they have some protection. This is not the case in China. In China, if you don't have a registration, you don't have any right over that aspect that you're trying to protect. And finally, the second principle, and this is very important for SMEs to know, is that territoriality principle. This means that the registration done within one country, it would only grant protection in the territory of that country. This means that any trademark or any patent that you have in the EU will not grant any protection in China. The same way, any registration done in China will not grant any protection in Europe. Also, in the case of China, we have to remember that for IP protection, there are 4 different jurisdictions. We have mainland China, Hong Kong, Macau, and Taiwan, and they work independently. So if a company wants full protection within the entire territory of China, then 4 registration will be needed. But what is digital economy and how intellectual property rights interact with the digital economy? A digital economy, there are several definitions. One says that it's economy based on electronic goods and services. Another one says that it's the economy produced by electronic business. Another one said that is the economy traded through the means of electronic commerce. So basically, they all agree that is that kind of economy of those business that are happening online. This brings some challenges regarding the IP protection, because we have the e-commerce, we have the artificial intelligence, blockchain, and now in China we have the internet courts. In e-commerce, we have the challenge of how to protect our trademarks in those markets that have access to our website, but we haven't done any registration. How can we start entering a new market? In the case of artificial intelligence, the main challenge is who is going to be the owner of those creations done by artificial intelligence? What happens if there is no human intervention? Who is the author? Who's going to be the copyright owner, for example? And in the case of blockchain and internet codes, they are connected with how to protect IP rights in the sense of the usage of blockchain as an evidence way, an alternative for evidence collection. And the internet courts are the new jurisdiction that was created by China a few years ago, 2 years ago, if I'm not mistaken. And they solve cases through artificial intelligence, and they work very, very efficiently. So we will discuss we will learn about them and how to take advantage of this new method of dispute resolution. But let's start from the very beginning. I mentioned before that copyright is very important for those companies that are in the digital economy environment, because through copyright is how databases and software it is protected. Databases are useful for those companies that use them as a method to perform business. It's useful as well for those companies that work with artificial intelligence, because through the data collection and data analysis is how they can help the AI to learn and to improve. But not only those companies or that section is the one that take advantage of databases. They do have copyright protection, as I mentioned. However, they also have to fulfill the the originality requirements, that is the requirements that the copyright law asks for any kind of piece of work to be protected. Originality means that it should be done with the effort of the author, that it cannot be copied. In the case of databases, what it is required is that, or what it should be original, is how the data, how the information it is presented. It is not, if you only have a simple list of names taken from another database, but you haven't done anything that brings any difference, that helps to differentiate one product from the previous one, it would not have copyright. However, if there was some analysis, if there was some data collection, some classification done by the author, then this database will be protected. And even collecting from a different source, just by a simple act of selecting, discriminating, and choosing some aspects over others, that qualifies as a method that qualifies as original. Software in China, it's also protected by copyright. It's not the only way in which software can be protected, but it's the main method of protection. Because even though software can be protected as well by invention patents, it is only kept for very specific cases, so it's rather an exception than a rule. Software can be protected as an innovation patent when the software it is involved in a more complex process that also requires the usage of hardware. However, in this more complex process, the hardware is unable to perform or to solve the main problem that the patent is trying to solve, but it's the software the one which is doing that. For example, in a process that is trying to manufacture any kind of product, if the hardware is unable to reach the final outcome, because there has to be a certain method of or different stages or different type of action should be performed in a very specific way, and the way that these actions are performed are decided by a software, then here we have a software that is connected to a hardware that is introduced in a more complex process. So here we have a potential invention patent. Now we go to the next topic, that is the artificial intelligence. So how do we protect the artificial intelligence? And here we have to differentiate the AI software itself and the creations made by that software. The artificial intelligence software itself, it will be protected by copyright, because what we have is a source code that take advantage of a database, but at the end of the day, there is no specific hardware involved. If we were talking about, for example, a robot that has artificial intelligence involved, then here maybe the robot could be protected with a patent. However, the source itself, it will still be protected by copyright. So when we talk about artificial intelligence, we have to separate the software itself than the software integrated to a more complex process. So one is protected by copyright, while the second one is protected, or most likely will be protected by invention patents. It has to be checked case by case, but this is the rule. But how to deal with those creations made by the software? What happened with those articles, with those other softwares that are done purely by the artificial intelligence? Then we have to analyze and differentiate three types of creations made by artificial intelligence. The first one is when the artificial intelligence is used as an instrument by human being. The second one is when the human and the artificial intelligence cooperate in the creation process. And finally, when the artificial intelligence is the sole and pure lonely creator of the final outcome, which brings to different possibilities. Who is going to be the copyright owner? Is going to be the artificial intelligence? Is going to be the person who uses the artificial intelligence? Is going to be no one? It's going to be the person that made the software. Who is going to be? And this type of this question was raised to a Chinese court, and there is one precedent. It's called the Shenzhen Tencent versus Shanghai in June. It happened in the Nanjing District People's Court of Shenzhen. Basically, this case can be explained like this. Tencent Beijing, they developed a software, an artificial intelligence software that was capable of analyzing different articles and make a totally new article out of those other articles that were analyzed. Tencent Beijing provided the license to Tencent Shenzhen, and they started publishing different articles. The method that this software that is called Dreamwriter work is that the employees of Tencent were selecting different type of business, in this case was business articles, and they were making a new conclusion out of all of them. Eventually, Shanghai in June republished one of these articles, and Tencent filed a lawsuit against Shanghai in June. The defense was very simple. There is no copyright infringement because there is no copyright at all. Since the copyright was done by artificial intelligence and there was no human interaction, then we cannot be talking about copyright at all, because the law requires an author, a human author. Well, what the court decided was different, and they made an analysis. They analyzed how creation it is done in general, and reaching to the conclusions that I briefly introduced before. The court said that in those cases in which the artificial intelligence is used as an instrument, for example, when the person just use the software for do some calculations, but the rest of the article is written by the human, by the author, human author, then clearly the software is used only for reaching some data purely to get some simple result that will be used in the final work, but no more than that. So in those cases, the copyright belongs to the human. Then we have the case of artificial intelligence with human intervention, which was the case of Dreamwriter. Because in this case, according to the court, there was a previous human selection of the articles that will be analyzed later by the software. So here there is a co-creation in between artificial intelligence software and human authors. So the final conclusion of the court was that this copyright belongs to the authors. In this case, was not to the people itself, but the company. However, we can check and we can see that the main principle is very clear. Every time that artificial intelligence is used as an instrument or with the human interaction, then we will have copyright over the person who did this preselection of information, who set all the rules, all the parameters, the factors that will be analyzed. That person will be the copyright owner. There is still no answer on the scenario in which there is no human intervention at all. What will happen when we reach the level of technology of artificial intelligence in which human interaction will be not needed at all. There is still no answer to that question, but again, we still didn't reach that level of technology. So from artificial intelligence, let's go to e-commerce. That is a very important topic on digital economy. And for those companies, let's analyze which are the main intellectual property rights and how to protect them. So you can start learning how to develop an IP protection strategy if you're planning to sell online. The main and most clear intellectual property right to protect is a trademark. As I mentioned before, trademark is any sign that helps your product to be distinguished from the ones from your competitors. So the most clear aspects are the company name and your product name. So you will be able to have the monopoly over the usage of your company name, who you are, and no one else. No one will be able to replace or steal your identity online. And also your product name, so no one will be able to copy them. That is very clear, I think. In the case of China, there are two methods of registering a trademark. The first one is doing it directly with the trademark office, with the CNIPA. And the second alternative is going through the Madrid system, which is an international agreement that allows companies to start the registration in their own country, in their own language, and then expand it to third jurisdictions. That in our case, mainland China is one of these jurisdictions. Also, it is important to protect copyright. And when we talk about copyright in e-commerce, we have to differentiate two different aspects. The first one is the copyright connected with your brand. As I mentioned before, logos can be protected as well as a trademark. But in the case of China, it is important to protect the logos also as copyright, with the copyright registration. Why is this? Because there is a common practice with bad faith sellers that what they do is to create a user, and when they try to offer products in bad faith, the platform will require a certificate that proves that they have certain intellectual property right over those products. If the trademark is already registered, they only have one possibility, that is to provide a copyright certificate. And they do this because to obtain a copyright certificate is very easy. It's very cheap. And during the registration process, there is no check of any background. So they only have to fulfill the document and the certificate will be granted. If this certificate of this registration was done in bad faith, then this should be proved by the real copyright owner, which in many cases it's quite difficult, especially if your company haven't done the registration in advance. So I think you can already start thinking why it is important to, when protecting your brand, doing a trademark registration, but at the same time doing a copyright registration. However, it's not the only thing that is advisable to register. You could also register pictures, photos, text on the script, or any description over your products. Because if you see that some of these products are being sold or offered online, it could be the case that they are also being offered using the same pictures that you use to promote your own products. And your company has the copyright over those pictures, over those photos, or even over the text that is used to describe the product. So through a copyright infringement, it is possible to take down this bad faith sale. Of course, if you also have the trademark copyright is just a secondary or just an additional method of protection. But in those cases in which we don't have the trademark, maybe yet, the trademark is still being registered. Since copyright, it is granted from the moment of protection, it could be as an alternative or a solution method to solve those scenarios in which we do not have the trademark, but we do have copyright. So my advice is to do the copyright registration of every logo and pictures, text, photos, anything that is related with the commercial aspect or the marketing aspect of a product, if you are planning to enter to the Chinese market, because it could mean the difference between being capable of proving bad faith or not. Another important intellectual property right is the industrial designs. As I mentioned, is the patent design patents, are the ones that protect the aesthetic aspects of a product. How do they look? Again, if they protect how do they look, we will be able to protect our products from those made by competitors and offered online. Even if the logo is different, even if the draw or the how it is color is different, if the design, if the shape of our product is the same one, then industrial designs design patents are the method of protection. And last but not least, companies should pay attention to trade secrets. Trade secret, as I said, is all that information that your company knows, your competitors do not know, and is providing you some competitive advantage. Those companies, when uploading information online and when providing details about the products, they should be very careful about what type of information they are disclosing and not giving and publishing any information that is relevant, confidential, and should be protected as with a different type of intellectual property right. For example, if your company do not have the trademark register in China, it would be risky to start offering in the Chinese platforms, online e-commerce platform, the products, because you will be disclosing what is going to be the name of your product. And since you didn't start the registration, you don't have any protection. Until that moment, you have to protect it as much as possible as a trade secret to keep it away from competitors. China got a new e-commerce law very recently, and it implemented some new changes. The most relevant one is the joint liability of the seller and the e-commerce platform, which basically was including the e-commerce platform in the liability of bad faith offer. The e-commerce platform will be only found liable in those cases in which they knew or they should have known that this bad faith offer and this bad faith sales was happening. Also, this new law brought an increment of the penalties, increasing the fines up to 2 million renminbi. And they also brought some necessary measures for intellectual property rights protection that e-commerce platforms should comply with. Now it's mandatory for them to have these IP rules. That's why most of the platforms already have these programs for IP protection, in which they also cooperate with the intellectual property rights owners, because that's also one of the requirements that is asked by the law, that they should interact and listen to IP right holders. They're also forced to include this notice and take down dispute resolution methods that we will discuss further in more details later. And it also established as a response time for the notice and takedown procedure. If, not very fixed period of time because there is no certain amount of days, but at least it says that the response time should be reasonable, which is understood in approximately 15 days. But how can an SME start preparing, how to control what is happening online, and how to prepare a potential case? Well, the first thing that the company should do is start to monitor what is happening in the market. They have to do regular control. Normally, it is advisable to have an expert, a native speaker of the language that can go and check every single platform to check what products are being offered, to try different concepts, synonyms in order to try to reach what are the main concepts that are being used online. Also, not only to check the e-commerce platform themselves, but also to be on WeChat, to check some groups, what is happening, to really be part of this consumer environment. And a very important aspect of this surveillance is not only to detect who is or what is being offered, but if we detect that there is an infringement, to start collecting evidence before doing any type of action. Because if we don't have any evidence, later we won't be able to prove that this infringement happened, so we won't be able to obtain any compensation. And it happens that as soon as, for example, a cease and desist letter is being sent, then the infringer, they take down the website or they take down the sales, and we don't have any method to have access to it. And of course, we cannot record it, and we cannot prove it, and we don't have evidence. So that the person who is doing the surveillance should be also capable of knowing how to collect this evidence, or at least how to report it in a method that the evidence would not be lost. For start thinking about the enforcement, I would advise you to follow these tips. First one, to register the trademarks in advance. This is critical because if you don't have the trademark, you actually have no right to claim. Any unregistered brand, it is free to use, technically speaking. Even if we consider that it's in bad faith because we know that it has been stolen from us, if we don't have the trademark in the territory, we won't have grounds for any claim. Then register your logo as copyright. This is what I mentioned before. Maybe we don't have a trademark, but what we do have is a copyright over the photos that are being used or the text that is being used for describing the product. So we may be able to take it down in this indirect way. Second, use blockchain, and this is something that we will discuss later, for saving evidence. Get evidence before doing any type of enforcement action. And blockchain, because they provide a live inventory and timestamp, the information cannot be modified in the future, is a good method of obtaining evidence. Use technology for trademark protection. Check online, check the databases, get familiar with the different apps about how to search for your trademarks and what is happening online. Many e-commerce platforms, they allow you to take a picture of a product and look those who are similar to yours. Try to get familiar with this technology and try to take advantage. But for enforcement itself, what different alternatives do we have? Well, we have the dispute resolution methods, which is the notice and takedown that every platform has. We have the regular court, that could be either people's court or even intellectual property rights. and we have the internet courts. Let's start with the notice and take down procedure, which is the most direct method of taking down one sale that is been happening in an e-commerce platform. Your company will need two types of documents. The first one is the certificate over the intellectual property right itself. As I mentioned, if it is a trademark, it's a trademark certificate. If we're talking about copyright, it's going to be the copyright certificate. Also, you will be required identity documents. Could be either your passport or it could be either the certificate, the registration certificate of your company, whatever exists in your country. What's the main difficulty now that is happening in this with this pandemic? What is happening is that in many cases we are required to submit documents that they need to be translated and they had to be legalized to be used in China. China is not part of the Hague Convention, so the legalization stamp do not exist or it's not valid here. The only method to legalize a document is to do the legalization process with the Chinese embassies in every country. What's the problem that brought the pandemic is that those restrictions may create issues or may create delays on the times to get these legalizations. So it is a recommended practice these days to, if your company is already deciding to do the registration of a trademark or to proceed with any type of enforcement, to check as soon as possible with the Chinese embassy in that country what are the expected times for doing the legalization and to start legalizing them as soon as possible. Otherwise, if you wait till the last minute, you may find out that you have a delay time of several months. So yeah, this is the practice and please pay attention to this aspect. But how the notice and takedown procedure works, well, the details it will depend on every single e-commerce platform. However, the law establishes a very clear general procedure that has to be followed by every single e-commerce platforms. Basically, the first step is that the intellectual property right holder should notify the platform about the infringement. This notification should go with the intellectual property right certificate, with the identity document, and with the link of the infraction, very clear. So you should copy paste and the link, so the person who's checking information can go directly to the infringement. The second step would be from the platform's side. They have to take those measures that are necessary in order to avoid or to reduce the damage that is being caused by the sale. Once that is done, which normally means that no one else can have access to this sale till the procedure is over, then they should notify the infringer or potential infringer, so they have time to provide their own defense to defend themselves, to say why it's not an infringement. They also have a reasonable period of time for doing this. Finally, once the defense is provided, the platform should notify the intellectual property right holders, and in 15 days, and this period of time is set by the law, the e-commerce law. In 15 days, the intellectual property right holders should decide if they abandon the action or they want to go further. And going further means that they want to present a complaint with the Chinese authorities or with the Chinese court. Regarding Chinese courts, as I mentioned before, it could be done with the People's Court, and we enter into the civil and commercial procedure, the general one. it could be done with intellectual property right courts, which are, they also follow the procedural rules, but the main or the most important part is that they have expertise on intellectual property right issues. So for those cases that are more complex, then it is advisable to proceed with this jurisdiction. And finally, we also have the new internet courts, which were made 2 years ago. They are very unique because as main characteristics is that the entire procedure happens online. They are very fast. However, the jurisdiction is quite limited. All the procedure happens online. Everything can be done simply with your phone. Even the evidence is provided online. It is very fast because on average, any case is solved within 27 days. And the main problem is that the jurisdiction, it is limited to very specific cases, which is the case of e-commerce. That's why we are discussing this jurisdiction here, but also online copyright, online service contracts, and domain name disputes. So, as I mentioned before, copyright, or having the copyright over a picture or over a picture of your product can also be useful because of this reason. If you want to file a lawsuit about trademark infringement, then you will have to go to the regular court or intellectual property right court. But if you want to debate with online copyright infringement, you will be able to obtain a sentence in less than a month, which is very useful in this changing economy and this changing online environment. And another important aspect, and with this we are almost finishing our presentation, is that the internet court, they are allowed to receive digital evidence, which is a case of blockchain. So what is blockchain? How it works? Blockchain is a method it's used for Bitcoins or during Bitcoins. And basically it's a method of saving information in different nodes that every node is connected, and they create a chain in a way that once a new node is added, the previous one cannot be modified. And basically what they do is to create a timestamp over that information that was included before. So what the Supreme Court said is that those digital evidence that, for example, the information about the website that is introduced in a blockchain, it can be presented, of course, it has to go with certain characteristics, and there are now some companies that provide the service of collecting evidence through blockchains, and they just give you the final access or how to just everything ready to be presented with the court. It can be used as digital evidence. So if you have, it can be used for proving either the infringement or also that you have been using a trademark, or that you are the owner of a picture of any piece of work in a certain moment, because registration, the main usage of registration is to have the proof that you were the author in a very specific time. That's why it's important that it has to be done in advance, and it should be the first one. But here, blockchain has the same, or gives the same purpose. This can be used for collecting evidence, for protecting trade secrets, proof of trademark, proof of copyright, and as I mentioned before, the internet courts, they have to accept it. So again, with these technologies, it is very useful, or it's very important to take advantage of them, because they will provide you alternatives that may not be in your mind. They may solve the case very quickly, very efficiently, and most importantly, in a very cheap way. Finally, some takeaway messages is register your intellectual properties as soon as possible. Remember the first to file rule. If your company wants to avoid any headache, start the registration as soon as you can. Get NDAs, non-disclosure agreements, and IP ownership agreements to secure your intellectual property rights when you are dealing with new partners, new clients, or even with your own employees. Please get everything, all the documents, and get all the contracts that are necessary in order to be sure that your company will be the owner of the intellectual property rights. Keep constant surveillance over the e-commerce platforms. Check what is happening. Check what is being debated, because this world is changing very fast. Prepare your documents in advance, so once you detect an infringement, you are ready to act. Collect as much evidence as possible before going to court. Otherwise, what you cannot prove, it never existed, and you may lose your chances of getting a compensation. And be proactive enforcing your rights. If you do not act, then you will not be capable of obtaining any result. Finally, if you have any other question, feel free to contact with the China IP SME Helpdesk. We are a helpline to support EU companies. We are, as Jennifer mentioned, free, fast, and confidential. We normally reply within 3 working days. So any feedback, any question, it is important for us. Feel free to reach us also in our social media addresses. And here you have the previous page. No? All right. All right. Okay. You can say.
Okay, thank you very much, Matthias, for the informative presentation, as well as the tennis. The case is really interesting, and also thanks for the comprehensive IP issue advice about e-commerce. And now we go through the Q&A section. Please feel free to ask any IP question from this presentation or from your daily business. And you can type your question in the chat box or raise your hand. We can give you floor and you ask your question by yourself. For the questions, I will read aloud, but not name on only the question, so everybody can listen and also learn this. So let's see whether anybody has a question. Okay. There's one question. One question to Matthias about trademark and copyright, because just now you mentioned also suggest the company to register, let's say, logo as a trademark as well as a copyright, and just for better protection. And if, for example, I register my trademark, but by maybe some misunderstanding, I didn't register as copyright, but I found an infringed case on e-commerce. Somebody get the business because to show the copyright. Is any chance for me to take down this infringe just to show trademark registration? Because I'm the owner.
Yes, if you have the trademark, you will be able to take down the infringement. We have to analyze or to know how trademarks work. When you register a trademark, you're registering, it could be either a logo, a combination of words, for a certain specific class, which is for certain specific products and services, and even more for certain specific subclasses, which is for very specific products. So if that trademark is being used to identify one of those products that are the ones that were chosen by you when doing the registration, then you will be able to take down the sales. What is happening is that copyrights may bring a broader method of protection because it's not related with the classes, and also they can be used for taking down those cases which you do not have the trademark, but also to settle a case with the internet courts and getting a sentence in a short period of time. Those are the main advantages. However, it is still, or practice still shows that having a trademark, it's way easier to take down a sales because there is no much to discuss. If a trademark is present in the product, the discussion is almost over, while with copyright, there's more space to debate. However, that's why I recommend to have both elements so you can discuss both aspects at the same time, or both elements are not exclusive, so you can try both ways.
Okay. Thank you very much. Thank you, Matthias. And next question is about collect the evidence. And would you please give us some suggestion about how to really collect qualified evidence in case of any infringement occur on the e-commercial platform? And also, just now you mentioned about notification. The notification must be done in China or can be also can acceptable if I notified in other country. I mean, yes, please.
Regarding how to collect evidence, if it is happening online, it could be done in two different ways. The first one is with the notary, public notary, that takes note about what is being offered, in which method, with characteristics, under which price, to record exactly what's the address, etc., etc., etc. This is the normal method of obtaining evidence. And if, for example, you're also attending a trade fair, this is the method that is normally used there to obtaining evidence. Now, regarding blockchain, what is the main advantage is that you can directly save all the information related with this website, include it in a node, and save it as a blockchain and present it as evidence. As I mentioned before, there are some companies that are already offering this type of service. So if you only send them the link, they will do all this for you and give it to you. And regarding the second part of the question, that is, if this has been notified in China or not, here we're talking about the Chinese market. Of course, when we're talking about e-commerce, it could be happening with companies from anywhere in the world. So the main point or the main element is that you notify the person that made the user that is being used in the e-commerce platform or online, to notify to take it down. If the website is a foreigner website, then you will have to go and notify them and follow these foreigner laws. And we are running out of time.
Yeah. Okay. Thank you, Matthias. Thank you, everyone. Now we finished the Q&A section. Here is you can see a QR code. You are welcome to send us any feedback or any of your opinion about this webinar or any other topics you are interested in, and for our reference. Thank you very much.